Hi, I'm Lydia Lockett from Holland and Knight.
Vivian Riveria, also from Holland and Knight.
And we are going to talk a little bit about using evidence strategically in trust and estates litigation. So just a little bit about ourselves first. I am a senior associate at Holland and Knight. I practice primarily in the realm of private wealth, fiduciary litigation, dispute resolution.
I am a fourth-year associate at Holland and Knight, and I primarily focus on trust and estates litigation as well.
Okay, so let's just jump right in. So the reason why we're giving this talk is to just sort of give you an overview of how evidence rules are important to your litigation case and making sure that you are thinking about evidence rules strategically throughout the life of your case, not just at trial. So we're going to be talking about the pleading stage, the discovery phase, some sort of interim phases, as well as trial. So just jumping right in, the first thing that you want to think about is pleadings. And when you are drafting your pleadings, it is important to make sure that whatever you're drafting, it properly captures what you're going to be able to prove eventually at trial. So if you know that you're going to have issues with evidence, it's going to be stale, hard to collect, hard to admit, hard to authenticate. A classic example of this is bank records. If you're trying to get bank records and you don't have them, and the bank records you're looking for are like 20 years old, consider whether or not you want to drop that cause of action. And the reason why I say think about this is, are you going to survive an MSA, an MSJ, and potentially expose your client to malicious prosecution claims after you aren't able to bring your claims? The other issue you want to look at when you're drafting your pleadings are presumptions. Who has the burden and what is the burden? And you want to look at the statutes. In the probate code, there are a ton of statutes that talk about presumptions. And the important key here is look for statutes that say prima facie in the statute itself. That means there's a presumption. And if there's a presumption, that affects whether or not you have the burden of producing evidence, or if you can shift that burden to the opposing party to prove the non-existence of an assumed fact. That can help lighten your load, and that can ultimately help maybe strategically help your case to settle before you even get to trial. So the next issue we want to talk about is discovery. Generally, the rule is not anything goes, but the scope of permissible discovery is much more broad than admissibility. So it's a different standard than from trial. So basically anything comes in unless it is clearly not going to lead to admissible evidence. And so just be careful about that. And a couple of key limits on that are the good cause requirement that is only required in certain cases, protective orders, and then when you have objections or motions to compel that you're dealing with. And the key here is to look at the specific Code of Civil Procedure statute that deals with the discovery that you're dealing with, because the burdens for justifying the need for discovery or sustaining your objections really depends on what kind of discovery you're seeking. So,
as part of that, there's also special rules when it comes to depositions. Depositions, if a party does not show up, you can file a motion. As part of that motion, you have to meet and confer with the other side. And if your motion is ultimately granted, then sanctions are mandatory, absent a showing of substantial justification. If a non-party does not show up to a deposition, the rules are a little bit different. There is no meet and confer requirement. Sanctions are not mandatory, but there are other minimal consequences. The non-party can be held in contempt, and there can also be a $500 sanction and potentially other damages. Now we're going to move on to special objections.
Sure.
Briefly.
So there are a couple of special objections that you're going to encounter a lot in trust and estates. You've got the privilege not to testify against your spouse if you're married. You've got the privilege to assert over confidential communications between spouses. The key there is that they need to be confidential. If your kids or some third party was there that's not confidential. Another issue that you want to be aware of in trust and estates litigation is the physician-patient privilege. While that's typically easy to assert in a lot of different cases, if you're talking about a deceased person and their intent, you're going to have a hard time because there's a trust and estates carve-out there. If you're talking about capacity or anything that's relevant to an issue as between all parties who are claiming through a deceased patient, there's a carve-out specifically for that, so be careful. Another big issue there is attorney-client privilege and attorney work product. The key with attorney-client privilege that you need to think about is who is holding the privilege. If you're talking about a deceased client, is there a personal representative appointed? If you're talking about fiduciaries, successor fiduciaries, remember the office of the fiduciary holds that privilege, so that the prior fiduciary, the prior trustee, can't assert that privilege against a successor. There's a few limited exceptions to that rule, but it flows with the office, and it makes sense policy-wise because the person coming in needs to have full information. The attorney work product privilege, one big issue there is estate planning files. Are they entitled to attorney work product privilege? Because they're not being prepared for trial purposes, and the statute says the policy is for trial, to protect impressions, mental thoughts, legal theories, research for trial. But remember, privileges are statutory in California, exceptions are statutory too, and there's no explicit statutory exception for attorney work product privilege in the case of transactional. There's a couple of cases that talk about that, Rumack v. Bottomley, and there's another case that's I think Los Angeles County versus the Superior Court, came down in 2000. So those are your privileges.
And finally, we're going to talk about evidence considerations at trial, the moment that you've been waiting for and building up through the discovery process and the motion practice process. The first thing that you should consider are motions in limine. These can be an effective tool to exclude evidence at trial, exclude certain witnesses, and it prevents you don't have to deal with those issues at trial. You could deal with them just before trial. One example, exclude documents that were requested but not produced during discovery. You can exclude a witness who failed to show up at a deposition, as I mentioned earlier. So these can be potential game changers that can have a dispositive effect on your case. Another pretrial consideration are entering into stipulations regarding non-controversial documents or exhibits that both parties just will agree are authentic or will agree to admissibility. Once you're in the trial, you need to consider an analytical approach to how you're going to move certain pieces of evidence or key testimony into evidence. The first is relevance. The standard of relevance is low, not as low as the discovery standard, but it is not an impossible burden to meet. It has to be probative. It has to relate to a fact of consequence. Moving on, foundation. You need to be able to lay a proper foundation for each piece of evidence that you want to admit. When it comes to a witness testifying on the stand, you need to show that the witness is competent, that the witness has personal knowledge, and if it's an expert witness, that the witness is qualified to testify and opine on the issues that the witness was tendered for. When it comes to documents, you need to properly authenticate the document. There are various shortcuts you can use to authenticate documents, including stipulations, which I just mentioned, pleading admissions, requests for admissions, judicial notice. There are self-authenticating documents, and lastly, and one of the more important ones, are third-party business records that can be authenticated with the proper affidavit by the qualified custodian. After authentication, there are a number of other hearsay issues that come up in trust and estates matters. A lot of out-of-court statements are not being offered for their truth, so they're not hearsay. They can be offered to show, for example, a decedent's state of mind. In executing a document, they can be used to show the effect that a statement had on a decedent or another party, which is non-hearsay, or they can be used to show that a party had notice of a certain statement. So these are all non-hearsay purposes, and you don't even need to get to a hearsay exception. But if you do need a hearsay exception, there are a number of exceptions you can use. The exceptions almost swallow the rule at times, but for trust and estates purposes, there's Evidence Code sections 1260 and 1261, which relate to a decedent's will, revocable trust, or amended revocable trust, or claims made against the declarant's estate. So that's just a quick summary of evidence considerations throughout the entire litigation process. And we hope that this was helpful. Thank you.